We're going to spend a lot of time talking about law this semester, so let's take a look at some of the areas of where law begins. One of the most common types of law that we're going to talk about is common law. This is also known as judge-made law. This is where judges will look at previous legal circumstances and standards, and they will make a determination on a present case. Now, during this opportunity, a judge can do one of really four things. One, he or she can accept what the precedent was and decide, okay, this is good law and we're going to keep this, we're going to apply it here. He or she can also modify that and say, well, the circumstances are a little bit different, so we need to kind of make a different determination here. They can also distinguish between different facts. So if the facts don't apply per se completely to the precedent, we can make an alteration there. Or they can decide simply that it's bad law and they can overturn that based on changes that we have on different facts that have come into play. Social values may have changed as we evolve as a society. And then philosophies of judges are different. Now, we're going to be reading a lot of cases this semester, and so I want you to be familiar with what you see when you look at these cases, especially as it pertains to the name. This is a pretty standard citation. New York Times versus Sullivan is a case we'll discuss. Now, in this case, New York Times is the petitioner. They have brought the case to the court in this case, and they are asking Sullivan to respond. So Sullivan is known as the respondent. The volume number where it appears in the case reporter, which is where court cases are held, is listed next, and then the page and the volume where the case starts is what will follow, and then the last thing that we'll see is the year that the opinion was issued. Another option that we have in law is what's called equity law. This is also judge-made law, but it's a little bit different in the sense that these are remedies that are decrees that are issued by the bench. So you'll see things like temporary restraining orders or preliminary injunctions, a permanent injunction. Those are considered to be equity law. Statutory law, as it implies, are things that are created by statute, so that means that legislatures are involved. These are kind of problems that are affecting society, so they'll anticipate where there are problems. This is where criminal law will fall in, so we anticipate if someone steals from you, that should be a crime, so we make that a statutory law. We put these together in code and law books, and this is what we call statutory construct. Now, constitutional law is what really provides the framework for our government. We're going to spend a lot of time talking about constitutional law specifically. It outlines the responsibilities, the duties, really the powers that government has as it does its job for the people. It's guaranteeing the people basic rights, and it's held in both the state and the federal constitution. And those two things both work together, and they create independent laws depending on the communities that they serve. Now, the U.S. Constitution is really the yardstick by which all other branches of government are gauged. It's the oldest, shortest written of any major constitution in the world. It's amazing how long it's lasted. We have 27 amendments, and of course the first 10 of those are known as the Bill of Rights, what we will spend a lot of time talking about, specifically the first one. Now, laws can be considered to be unconstitutional for a couple main reasons. One, it's vague. So somebody of reasonable intelligence really wouldn't be able to tell what was allowed or prohibited. The same token, it can be what's called overbroad, which means it is such a blanket approach that it's going above and beyond what we really need to do in order to either provide opportunity or take opportunity away. And now one of the other areas that we'll look at in terms of how law is made are executive orders. So these are orders that are issued by the leaders in a community. That could be the president, the mayor, the governor. These powers may be defined by the state constitution or the federal constitution. The goal is, of course, that they're monitored by the other branches of government. That's part of that check and balance system that we have. And then we have administrative rules, which I'm sure you've seen and not even maybe realize what they were. So when commissions make rulings like the Federal Trade Commission, the Federal Aviation Commission, the Federal Communication Commission, those are administrative rules that they're setting forth. They're very specific areas that are tailored to an area that's too specific for the legislature specifically to deal with, but it requires kind of expertise on that particular area. So when we're looking at broadcast rules and things, we don't want per se the entire legislature to be making those decisions. We want someone who's specialized in that, hence the Federal Communication Commission.